And call the next case of 116524, State of Kansas versus Howling. I would expect that he will join us when he's available. Mr. Kittle.
Again, I'm Rick Kittle. I represent the appellant, Mr. Howling, and I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is reserved.
Just to kind of give a procedural background of the case first. In this case, Mr. Howling was charged with rape and aggravated criminal sodomy of his 4-year-old daughter. The girl is referred to by the initial M in my pleadings. A jury found him guilty of aggravated criminal sodomy, but not guilty of rape. The case was appealed to the Kansas Court of Appeals. There were 2 issues raised, one which concerns a forensic interview, a video of a forensic interview conducted of M by a woman named Casey Corbett, and whether that should have been admitted at trial over defense counsel's contemporaneous objection at trial and over the motion in limine that had been filed by defense counsel, and then an issue challenging the sufficiency of the evidence. The Court of Appeals affirmed Mr. Howling's conviction, and it was taken up on review by this court. It strikes me in view of what happened in the previous argument that maybe Justice Biles' question should be dealt with first from the previous argument regarding what is the opinion that was offered, and I assure you I'm trying to get to that point, but it's going to take a little bit of explanation. In this case, we're dealing with the Child First Protocol, just as we were in the previous case. Not at trial, but at a pretrial hearing, a woman named Kelly Robbins testified in this case, and she is the woman that created the Child First Protocol. And in her testimony at pretrial hearings, she explained the whole purpose of the Child First Protocol, and my takeaway from her testimony is it's basically twofold. It's 1, to safeguard the child, and 2, to use techniques that she describes that will achieve a reliable result. Corbett came in at trial, and she is the person who, and this was identified as a forensic interview at the time of trial, she is the person that conducted that. She came in and she testified a little bit about her training that she had undergone to do this type of thing, and explained a little bit about her understanding of the Child First Protocol. At the end of her explanation on direct examination of the Child First Protocol, she was asked, did you apply the Child First Protocol in your interview with M? And she said that she did. To me, that's an opinion, because that was the subject at trial that was in dispute, whether she had properly applied the Child First Protocol in this case. The defense calls its own witness, Dr. Steffen. And Dr. Steffen comes in, he testifies as to his expertise, he testifies that he's viewed the video in question here, and he makes criticisms of Corbett as she conducted this interview. He says she never established that the girl knew the difference between a truth and a lie. He says that she never established ground rules at the beginning of the interview so that the girl knew that there's no such thing as a wrong answer. She's just trying to get information here. The fact that at one time M displayed some fatigue, and the protocol will dictate that you maybe distract her and go to a different area, but it appeared that Corbett just continued to plow through with questions, and then also there was a criticism of the nature of the questions asked, that they were leading and suggested an answer to the girl.
Can you back up here?
Yeah.
You just previously mentioned that Ms. Robbins, who created the test protocol, testified at preliminary hearing.
She testified at a pre-trial.
A pre-trial.
But not at trial.
Not at trial.
Right.
But did Robbins offer any opinion as to whether Corbett rendered or conducted the interview in a manner consistent with the protocol?
I don't actually recall that in her testimony, although...
So what was the purpose of her testimony?
I think her testimony was just basically to explain what the Child First Protocol was, because it was clear that that was the method that had been applied.
Did it encompass questions about the reliability of what she had developed?
Again, I would have to look at the record and see exactly what it was. My recollection of it right now is that it was done for the purpose of just giving an explanation of what this protocol was.
Wasn't
so
the context the motion to suppress the interview?
The motion in limine, yes,
Yeah.
was to suppress. The motion in limine was filed because it's our contention. Well, the state's contention here is that Corbett, not Robbins, but Corbett was not an expert witness, and that the video does not constitute expert testimony for purposes of 6456. Our argument is that those are both incorrect. And the point I'm trying to get to is why I believe that that video interview constitutes expert testimony.
Is that attack an attack on the protocol, i.e. the protocol's junk, or is it attack on the interviewer, i.e. the interviewer botched the protocol?
Conforming to it.
Or is
right.
it both? They're different.
I think there were probably references to both in here, but what's being advanced here is that Corbett did not properly apply the techniques that both she and Robbins
So
identified.
you're not making a foundational attack on the protocol.
no.
You're saying,
saying
it
it's-
wasn't followed.
Right.
Okay.
That's the opinion. She said, I followed the protocol, and that's why that makes
That's
that
part
the
of it.
opinion.
That's part of it.
Okay.
The other part is, after the defense, and I just mentioned this, after the defense called Dr. Stephan its expert, Corbett was called back to the stand as a rebuttal witness. And in her testimony as a rebuttal witness, she goes even further into the Child First Protocol and what it's about. And she specifically addresses some of the points that were made by Dr. Stephan in his testimony. That's the purpose of the rebuttal witness. But she is testifying at that point and answering his criticisms. She's explaining why, during the course of the interview, she did something or did not do something and how that meshed well with her understanding of what the Child First Protocol was. So at that point, I would argue that she is testifying as an expert. She clearly has knowledge based upon her training that the lay jurors don't have. She's giving her understanding of the Child First Protocol. She has testified that in her opinion she followed the Child First Protocol in conducting the interview with him. And for all of those reasons, not only is she an expert witness, but the greater the likelihood that she is an expert witness, it makes it that much greater that the interview that she is specifically pointing to and explaining how she applied those techniques of the Child First Protocol in this particular interview, it makes that video also expert testimony. That is the physical manifestation of her opinion regarding her application of the protocol.
Counsel, let me back you. I'm looking at the transcript because something you said didn't register with when I looked at it last, which was since I've slept. The part where you said she followed is that the process you followed? Is that at the top of page 22?
I can't tell you, but I remember it being at the top of the page where she had just finished her explanation of what she had done, and this is direct examination. She's asked if that's the I don't remember the exact language.
Well, I mean, the problem I'm having with if that's what you're keyed off of, to me, the explanation she gave before was talking about how she showed a doll and did those things, and then the question is that what you did in this case? And she said, yeah, I did that. I don't see that as as being an expert opinion or even an opinion that she followed the Child First Protocol, because that's not the question. The question is a follow-up to her explanation about what she was doing with this victim in the interview. And I just don't see it. If that's the point, I don't see it.
Well, I'm not relying solely on that. I guess I would disagree with you. I think that's an opinion as to whether she did or did not do something according to Hoyle. Then, yeah, I believe
That's
that was
not
an
the
opinion.
question. She said she did certain things, and she described a process. And he said, well, is that what you did? Yeah. I mean,
Well,
the context of this is much different than, I think we're trying to make more of this than what's really here.
and there is more to it, and it's what I just described in her testimony as a rebuttal witness.
Okay.
Because when she gets to rebuttal, she goes into much more detail about not only the protocol itself, but her application of the protocol in this particular case. And as I said, one of the things that she was criticized by Dr. Stephan on was the fact that she had never established that the girl knew the difference between a truth and a lie. She basically acknowledged, no, I didn't establish that. But then she gave her explanations for why she didn't think that that was necessary in this case, again, meshing with the protocol in which she'd been trained. One of the things Dr. Stephan criticized her about was not establishing ground rules at the beginning of the interview so that, if she said, she could say, I don't know, or I don't remember, or I don't understand. And that wouldn't be a wrong answer. Trying to get a truthful response from the girl rather than just the girl telling Corbett something that she thought Corbett wanted to hear.
I'm struggling with whether deviations from the protocol equal unreliability. And I don't think your expert even went so far as to say this interview was unreliable. There were things he criticized, but did he ever say this was an unreliable interview?
I suppose my recollection would be that it was more of an implicit opinion on that it was not reliable because of all of these different factors.
And why can't the jury heard all of that? Why is that not sufficient if at the motion in limine the judge wasn't presented with clear evidence that this was unreliable? If the judge made the findings at the preliminary hearing, denied the motion, to let it go to the jury, correct?
Right.
And what would the standard have been for the judge at that motion in limine to have cut it off at that point? And why is the record sufficient at that hearing?
Well, our argument is that this is all subject to review under KSA 6456B. My understanding of that statute is that it's basically a three-part test. One, is there a factual basis for an opinion? Two, is that opinion based on recognized methods and techniques? And three, have those methods and techniques been properly applied in the particular case so as to yield a reliable result? And it's that third part that we're hanging our hat on.
But what was the evidence presented to the judge that made it clear it was unreliable? Because I didn't see anything in the expert's testimony that kind of tied that up.
I guess my point would be that the things that I've just mentioned, I agree. I mean, I don't recall him making a specific statement, the result of this interview is unreliable. But he certainly did criticize the methods used, that they were outside not only what he would have done, but also outside particularly what was called for by the Child First Protocol.
I'm sorry.
To the extent that the Child First Protocol is not properly applied, its methods are not properly used, to that same extent, it renders the result of the interview unreliable.
And what is our standard of review of the trial court's contrary conclusion to that?
I think I set forth that lengthy standard of review in my brief based upon the State versus Shadden case at 290 Kansas 803.
Because it sounds to me like you're asking us to reweigh what evidence the trial court heard and come to a different conclusion than the trial court did.
Well, perhaps to an extent I am, but the immediate question to me is whether this should be subject to KSA 6456. Once we get that question answered, then I guess then we take a look at the particulars, the evidence. And so I guess that's the threshold question here. The problem I see is prejudice. Maybe I'm trying to perceive where you're going to, but if you remove this forensic interview, then what you're left with in this case is evidence that is inexplicable in one sense, incomplete, inconsistent. In this case, I'm out of time here, so
I have a quick question.
Okay.
Would you agree with my earlier speculation, I guess, that this is comparable or analogous to a forensic crime scene investigator who has protocols that are in place to prevent the contamination of, for example, the collection of DNA or biological material?
I mean, I see a similarity to that.
Well, follow up, is there any reason we should treat this differently than the way we treat those kinds of questions?
I think there is, because in this situation, you're dealing with a human being. You're dealing with a child who, you know, there was made an analogy made here, I think in the previous argument with regard to the interrogation of a criminal suspect. Well, in this case, you have a child. When you have a suspect, you have somebody who is presumably an adult or who has safeguards. If he's in custody, there's going to be a rights advisement. He's going to be told of his rights. That's not the situation here. You have a child who's very impressionable, especially at the age in this case, and therefore that creates all the more need for whatever protocol is in place to be followed.
That's why I just analogize it to the crime scene. It's like you have fragile evidence, shall we say, and you
Right.
want to put protocols in place so that that fragile evidence is properly collected and not contaminated.
Right, and you know, in that situation, you know, I'm not sure if evidence that maybe hasn't been properly collected is not. It's not necessarily just going to be put to the side. You know, that may go. The court might determine, well, that goes to the weight of the evidence rather than its admissibility.
Was there any testimony that the Child First, formerly known as Finding Words, was the only protocol that would result in a reliable interview result?
I don't
My
recall.
question is that just proving that there were questions that were off protocol doesn't mean that you can't get lucky and have a reliable interview result. In other words, Child First is not the only protocol in the world that will give us a reliable result, is it? Is that the only protocol that will
I
work?
don't recall that there being any testimony specifically to your initial question. I mean, there, like I said, Kelly Robbins testified, and there was evidence at trial that there was a protocol called Finding Words that she had also created, as I understand it, and that this Child First protocol was kind of the version 2.0 of that, somehow improved. I really don't know what the improvement was supposed to be.
But did she testify that that's the only way to get a reliable?
No, I don't think anybody ever
Result.
testified to that. But the message from the state's evidence is this is something you can rely on, but it has to be properly applied. And our argument is it wasn't in this case, and therefore the result is it yielded was not reliable. And that's why if it comes in under 6456, or if it's considered under 456, it should have been. It should not have been admitted as evidence in this case because it doesn't satisfy the test of that statute.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. Kelly Robbins did not create Finding Words Child First protocol. She's not the creator of any of this. She does teach it. She's not the creator. Setting aside that factual inaccuracy, I feel like I'm facing a moving target entirely. At the motion in limine, what Mike Brown put was that Ms. Corbett would not be called upon to render opinion as to whether or not MH was truthful. However, the defendant contends that she was not qualified to conduct a forensic interview of MH, and the Child First protocol was not followed. Thus, any evidence of the interview of MH should not be admitted into evidence as not being reliable. The objection at trial was based purely on the interview. The Court of Appeals decided only the interview was not expert testimony. And now there's an attempt to bootstrap everything else that happened to somehow make it expert testimony. But the only thing that's preserved here is whether or not the interview itself is expert testimony. And the answer to that has to be no.
Why?
Why? Because the interview is not an opinion. I'm sorry, I didn't.
it's not an opinion, but as you've heard this whole discussion, isn't it bolstered by the whole use of this Child First protocol and its validity? And if you utilize that protocol, it renders some sort of higher form of reliability or accuracy. Isn't it the whole purpose of using this interview technique?
The purpose of using the interview technique is not to be unduly suggestive with children so that we properly interview children. Yes. But that doesn't mean that the interview itself suddenly becomes expert testimony. If there is some kind of expert testimony in any of this, it might be anything that implies the Child First training or the protocol is indeed reliable. But that didn't happen here. We didn't say this is the most reliable training, this is the only reliable training. They just described the process. Corbett here was essentially a witness for foundation. She was foundationally explaining what would occur on the video. This is the protocol I used. This is what you're going to see in this interview. And then the interview is played. Then they use, and rightfully so, a defense expert on child interview techniques to point out why they think this interview technique is not perfect and any flaws that might have occurred during the interview that could affect the reliability of what the child said during the interview. That's exactly what should occur in these cases. It is much like what Justice Siegel has said. It's like if you have a highly trained forensic specialist, you're trying to avoid contamination. We're trying to avoid a bad result. If the child is suggested what happened instead of telling us in her own words what actually happened.
And then the witness comes back on rebuttal.
Correct.
Okay, and how is that not opinion to contest the opinion of the defense expert?
Her opinion is just that she followed the protocol. He was saying that she didn't do these things. It is an opinion. It's also an unobjected to opinion. So I don't think it's to the extent that there's some issue with what she did, it was not properly preserved. And certainly was not raised before the Court of Appeals either.
How do we know that the Child First protocol is viable, is accurate, is reliable in any way?
Well, in this case,
how are we assured here? Isn't that if you're going to rely on something, your interview, your person that you're bringing before the jury that interviewed the witness and the victim here and says this is what happened, how do we know that the technique that she's employing renders an accurate recitation of what occurred?
well, in this case, the Child First protocol was never attacked as being unreliable. That's the point of my reading the defense motion in limine at the beginning. They didn't argue that the Child First protocol was unreliable. They argued it wasn't followed. Those are two different things.
Right, I understand.
But what you could do is exactly what I think occurred in the prior case, but not this one, where they had a hearing on, I don't actually know, I'm not that familiar with the blue facts, but you could have a hearing on whether or not the protocol itself is reliable. And if we're going to put on someone like Kelly Robbins, who I think is unquestionably an expert in finding words.
Because she teaches it?
She teaches it and trains in it. She's a trainer, more specifically. Then we might be trying more to say that this is a reliable interview process, but we didn't do that here. But I think
you could imagine circumstances where defendants might argue, hey, this interview is not reliable because they didn't use the protocol.
Correct. Absolutely.
And that's essentially what we kind of have, this case is the opposite bookend of the one we heard earlier.
Correct. Are there any further questions? If not, I respectfully request you affirm the Court of Appeals that this is not, the interview itself is not expert testimony, which I think is the only issue properly before this court.
Any further questions? Thank you, counsel.
Thank you. Actually, I'm sorry. I did want to point out one other factual inaccuracy. I don't know what counsel is referring to as an expert testimony that would have happened on direct. The closest thing I could find, my page numbers might be off, but I have as record 925, where she does say, is that the process you used when you interviewed MH? And she just says, yes, it is, but that's after the discussion of the RATEC process. And part of the reason the prosecutor talked about the RATEC process is because they knew a defense expert was coming. And so the defense expert's not going to make any sense if you don't know what the process is. Again, she was just a witness for foundation.
Counsel, before you step away, I want to apologize to both of you for coming in late, but I do have, I thought I had a question, now it's escaped me. I may have to ask opposing counsel. All right, thank you.
Thank you, Your Honor.
Oh, I'm sorry, I just thought of it.
Absolutely.
Opposing counsel has asked, what standard of review do we apply to this whole situation? I'd like your response to that.
In my brief, I argued abuse of discretion. I think the Court of Appeals said it's de novo because it's interpretation of the statute. I think if you are trying to interpret the statute, the Court of Appeals is right. If you're just trying to figure out if this was properly admitted testimony because it was reliable, then it would be abuse of discretion.
All right, thank you.
Thank you.
In one of his pleadings, the state cited to a case of this court called State versus Wells, and there was a quote in the pleading that said, quote, expert testimony regarding certain child interview techniques in child sexual abuse cases generally can be admissible. Experts may testify about proper and improper interviewing techniques to be used, as well as about the problems they perceive with the interviewing techniques used in the particular case. If that's what an expert witness does, then I would submit that Corbett was testifying as an expert witness in this case, particularly when she's on rebuttal, was explaining why she did certain things during the course of the interview.
How do you respond to the state's contention that that's not before us?
I would argue that's all part and parcel of whether she is testifying as an expert witness and whether
What the state says, I think, pretty clearly, the only issue here is the admissibility of the video.
when you look at the Court of Appeals opinion in this case, it pretty clearly states that the state is saying not only one, she is not an expert witness, and two, the video in this case was not expert testimony. So I think that, and that's why I'm addressing both of those in this situation.
But was it preserved for the Court of Appeals? Did the motion in limine or any objection at trial preserve that?
I'm not so sure about that, but I think that's part of my argument as to why the video is expert testimony. If she is testifying as an expert, it makes it that much more likely that the subject that she is particularly testifying about becomes expert opinion testimony itself.
Do you have any further presentation?
No, Your Honor.
And what are you asking us to do?
I'm asking you to reverse Mr. Howling's conviction, and I would submit the other issue that I really haven't addressed here on the brief for the court's consideration.
Counsel, I want to follow up on the objection issues. I'm looking at the transcript here. When Mr. Brown makes the objection before they play the interview during, this is Corbett's testimony, all he did was object and renew his motion in limine. So the grounds for admission are going to be limited to
What's
the
in that
motion in
motion?
limine.
Yeah.
Okay, just so we agree on that. Thank you.
Any further questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement